Доброго дня.
Good afternoon. Today we gathered to conclude the initiative Tribunal for Putin during the last 4 years. My name is Alexandra Romansova, the Executive Director of the Center for Civil Liberties, one of 3 organizations which established this initiative. And our organization, since 2014, together with our colleagues, we are documenting the Russian war crimes. It is important for us to remind everyone that in fact we have more victims than those millions affected since 2022. We also have to remind about 2014. 2014 was the first sign of everything we somehow got prepared to, and we started the documenting of the crimes against humanity and episodes of genocides, which in March 2022 started this initiative. The 2 other organizations we established this initiative with is the Kharkiv Human Rights Group. Today we have Yevhen Sakharov and also Ukrainian Helsinki Human Rights Union. And today we're going to talk about what about the results of our cooperation. And let me start from this small excursus. During the last 3 years, lots of organizations joined us, more than 40 of them. Many organizations started their processes of documenting since 2014, but there are also the other organizations which joined the process in 2022, and one of them, for example, today we have Miss Yulia. And today they have a nice, wonderful name, Clear, and also the organizations which, in fact, have unique forms of organization, like Truth House, which at the moment, Truth Hounds, which at the moment I think they are investigating the big cases, and we have Zira Kozleva from this, and the first head of the Association of Relatives of Kremlin political prisoners, represented by the head of this organization, Igor Kotelyanin. So what are we going to do today for you to understand when you will be able to ask all the questions which I hope you have? I will show the presentation, and I hope that it will take not more than 15-20 minutes to explain where are we now, where is our initiative, what are we doing, and as well as every initiative which appeared when some people had to leave, when some people had to stay here, and some of us had to go to the office. Some of us had to hide. And we were thinking, what the people who have 2 main principles is to care of the human rights and also to never to take the weapons in their hands. Unfortunately, we do have the colleagues who had to take the weapon, and they stopped being protecting human rights, because that doesn't go together. So we started to think what we can do first to stop this aggression, and B, for the results of this aggression not to become the new reality. And therefore, T for Tribunal for Putin decided that is a justice we want to bring to each person who was affected by the Russian war in Ukraine, and also Ukrainian society, and maybe somehow even historical justice. And we have enough of, for example, Kharkivska Human Rights, Ukrainian Helsinki Human Rights Union. They have their vision, and we were working on in different conflicts in Caucasus and Baltic countries conflicts, and we understand that it's a unique situation because the conflict is ongoing. We understood that it's not going to end up in 3 days, and starting doing something, we were motivated to do something because in 2014, right in 4 days after Yurkin has moved from Slaviansk to Donetsk, our first mobile group, which consisted of 2 activists, 3 journalists and 4 activists, we came to Slaviansk to document these crimes, and we understood that we cannot guarantee that all these evidences and these objects will be in the same situation, in the same state, and we will be able to document the place of the crime. The war is unique because it is erasing the consequences of the war, and therefore it was important for us to understand because we understood that we did not understand whether Kiev was sieged or not, and we started with Osint, as everyone did, and we were thinking how it should actually be. It's one thing when you're documenting the part of Donetsk and Luhansk Oblast and the Autonomous Republic of Crimea, and another thing when you're documenting around 25% of the temporary occupied territory, and in addition to that, those cities which were bombed the most, comparing to. So we decided that we have to document as much as possible and all around Ukraine. That is unique methodology which allowed us to have the partners in each of the regions, and many of these organizations have the European Human Rights Court, and now we have the network of 40 organizations, and we are ready for the new methodologies of documenting and for the new reality in Ukraine. So what we identified as our main objective of our initiative, because each initiative is willing to be unneeded. In fact, the human rights activists dream for their services not to be needed. So we decided that it's going to be documentation of the war crimes, and also that is the international identification. We understood that with money we can create the informational vacuum where everyone gets used to the fact that in Donetsk, Luhansk Oblast, there is some civil war, and the Autonomous Republic of Crimea has always been Russian, and we have seen that back in 2016, and we understood that we need documenting for justice to come legally, and the document is needed to make the political decisions based on facts by our international partners. So the international advocacy was one of the key objectives. Informational activity, of course, because the understanding of the scale of the losses, the understanding that the Russian Federation attacks just the servicemen, and that is their fault. There is a war in some certain regions, and we have to explain that. Before that, I think that the uniqueness of the Tribunal for Putin is that Kharkivska human rights group has opened it in 8 languages, and it helped to create the vision of the situation and suggesting the information in 8 languages. And the fourth one, of course, we understood that the submissions to the International Criminal Court will not stop the war right now and here, but the international mechanisms which exist and which we believe in as human rights activists, because one of the functions they do is condemning the aggression. Therefore, it was also important for me. As of the 20th of March, we have 84,396 episodes which were analyzed, which were the lawyers were able to formulate what kind of provisions of the Rome Statute match these episodes, and this system, which of course reflects the public statistics on the website, but nevertheless, in fact, it has the unique information which we got from 40 organizations, and thanks to lawyers and thanks to field trips, field experts who were going to fields, we were able to process this and open the unique cases. I'd like to draw your attention to one of the biggest numbers, in fact, in this database, and pay your attention to the fact that actually it proves in that somehow there is genocide framework of this war. 3,745 damaged or destruction of historical monuments, which are humanitarian, or the ones which help to identify our identity, meaning that there are cultural, historical monuments. And, for example, if we are talking about Russian Federation using the religion as one of the identities of the Pax Russia, and therefore we can say that in Ukraine we have 72 types of religious communities where we have the groups of people who have unique religious buildings. For example, Karaimsk Kenasas. In this case, we can see that the Russian Federation is trying to erase everything possible. In this case, a religious building. And that is one of the big targets for the Russian Federation. 17,421. That is attack on the civilian objects. So not the places where there were some military points or the servicemen were. And that are the places where people were working or residing. Only civilians have been there. And the biggest cases we can be talking about now that they were covered by the colleagues using this accumulation effect of our database. That is Bucha investigations, where our monitoring groups were in 2 days after the occupation, thanks to the separate, actually, permission from the armed forces of Ukraine. And we've been there before Bucha became the unique object of informational cooperation with international journalists. And of course, that is Mariupolsky drama theater. In Mariupol, we have 2 super detailed works which describe how in Mariupol genocide was happening and how the city, which does not exist now, is covered in details. How the first work of the Kharkivska Human Rights Organization, and the second one is Truth Hounds. There are 2 big investigations on Kakhovska Dam or Zaporizhska NPP, and here we have the separate investigations of Truth Hounds, and also we have the investigation of the relatives of the Kremlin prisoners, and also the situation in Enerhodar. And of course, one of the most painful things at the moment, and the most painful cases, that is the Okhmadit case, children's hospitals, which we have described in the cases and applied in different ways in different applications. Beside that, we are talking about forcible abduction, 3,253, 8,170 wounded as a result of shelling, and 5,775 the deaths of a person as a result of shelling. So 3,253. Our active work of our initiative was that in the future we are going to search for these people on the territory of the Russian Federation, because the majority of those who were exchanged or returned from the detention centers, from prison, that were the people who had no contact with their relatives, who had no legal representation, and they were incommunicado in the Russian Federation. It means that in our best hopes, every person out of the 3,000 is possibly still alive and might be illegally kept on the territory of the Russian Federation. Of course, we get lots of the requests from the relatives who are asking to help, who we are supporting to. So they did their best to include all the mechanisms which are available in Ukraine for searching and and to be able to return these places if this person is in the captivity or in detention. As I already mentioned, international advocacy is important for us because of two reasons. The first thing is that we were so afraid that the scale of this invasion will not be understood by the European Union to start supporting us immediately, as well as our partners in the other countries. And Ukraine has traditional diplomatic economic coordination with some of the countries. We also paid attention, and here you can see some photos. So we started to work with the countries which has a big way, but in the regions which are not covered by Ukrainian communication, that are the countries of the Global South or Global Partnership, and also Southern Africa, Brazil, Argentina, also North Korea. So all of these countries which in fact in traditional way coordination they have the impact, they have their own interests, and they are able to be potential partners of Ukraine or the Russian Federation. So our international advocacy was directed on three factors. The first is to prove the scale of the catastrophe and that there is a need for the immediate response, economical, military, and the other ways. So yes, it was in fact weird to be talking about weapon for the human rights activists because human rights activists they are using peaceful methods, but at the same time we were using our possibilities, the information we are collecting, the possibilities of the analysis, and the possibility to show that it's systematic, because abduction, tortures, humanitarian objects like schools, universities, kindergartens, hospitals being used by the Russian servicemen. So all of these things are happening since 2014. And at some point, the work which started before we established the initiative gave us the opportunity to show this pattern. And also our international advocacy included cooperation with the colleagues from other countries, also the colleagues who were able to compare the crimes committed by the Russian Federation in Chechnya, Syria, and Ukraine, and to show that lack of punishment, that lack of response in many ways leads to the higher scales of the tragedies we are observing at the moment. So as you can see, here we have our great colleagues who were present on various meetings in the Council of Europe, in the UN, in the EHCR, in different countries, including the countries of the Global South. And of course, we were using the opportunity given. So here we have, in fact, two people, the Nobel co-receivers of this prize, the Center of Human Liberties and Memorial, and Kharkivska Human Rights Group is a part of it, and they were able to work with the politicians of the higher level, which gave us the opportunity to deliver some certain messages. When we were talking about ideas, we were always suggesting the Tribunal for Putin and to analyze the partners. We were suggesting what can be done, and the support of the international of the national cooperation was that not only that we are from our childhood for this idea, but also in some suggestions, and it was happening the same way for all the cases. So our organization doesn't want to be the organization which reminds the country which is helping us to protect, and we deeply appreciate it. But beside that, we are suggesting the options. So informational activity consisted of various formats, both this specific one, for example, through MISEP project, and also documentaries, and also Shadows on the Left Bank, that is the documentary. And we were combining different types of creative arts to show it, because yes, indeed, we have fatigue, but this fatigue is the only thing we can agree on, and we cannot just agree, and we will continue talking about horrible things, and you can rest. So we were trying to find the new ways, and in fact, many of them had this. So, of course, you can see the results of our field work, but documentaries and the performances helps us to engage in the process various groups of the people. And one of the members of our initiative despite fatigue, despite the unique material we have, and at the moment the war crimes are the most documented all around the world throughout the history of the humanity, we were helping to form the unique project, which was established by DocuDays, but at the moment that is an independent project. The War Archives, and it became the unique database which collects data about everything that has happened and somehow reflected in media and in the future in the interview formats. So all the things we've done has legal trace, and it has formed, it cost 8 submissions. You can get this kind of leaflet, and here you can find the QR codes for each of these submissions, which we have done during the last 3 years. Using the joint database Tribunal for Putin. And now we're talking about the submission to the International Criminal Court. And with this, I will pass the mic to my colleagues. Why the International Criminal Court? Even before the ratification, and Tribunal for Putin and all the partners we're advocating for the ratification of the Rome Statute because we consider it to be a systematization of the justice. Our 8 submissions, first of all, happened because this mechanism has to respond what is happening on the territory of Ukraine. Beside that, we had the submissions to EHCR. In fact, we had lots of them. We had the submissions to the special groups of the UN. There was a constant work with the monitoring commission of Bureau of Democracy and Human Rights and OSCE, and of course the active work with the Moscow mechanism, one of the few ones of USCR, which help to reflect the situation without monitoring mission of OSCE. So they concern the biggest group of crimes. I'm not going to dive deep into them, and I will ask the next speaker, Mr. Yevhen, to cover them. So, recapping. In 3 years we managed to collect the unique database. And of course, in cooperation with the official investigation authorities in Ukraine, we exchange this information, but we understand that are the independent evidences of Ukraine not exaggerating the numbers just to use them as an advantage in the military conflict, because Ukraine as a state is a side of the armed conflict. We, as the human rights activists, as people with standards, as people with image on the international level, we were always able to be talking about the data which we have collected. And in this way, we can prove or not prove some official statements on behalf of Ukraine as a state. On the other hand, we consider it a huge result, because though Ukrainian society was not interested in the situation during the last 8 years, if they didn't have the relatives of some temporary occupied territories, they were not interested that around 20,000 war crimes were documented before 2022. At the moment, the understanding of the war crimes, the standards of the international human rights, the need to ratify the Rome Statute, they became the common knowledge in Ukraine. And most of the colleagues we are working with, they were already working, but we can see this shift, and we consider that we contributed to this shift. So please do not forget that we have a fantastic website, t4pua.org, which had the support recently, and now we are looking for the financial support. You can see the recent statistics, even newer than I've shown, and you can use a QR code. And I would like to remind you that thanks to Kharkivska Human Rights Group, we have it in 8 languages, and there you can find the detailed information not only about these statistics, but about the groups, the formats, and the other things which happened since 2022. And now I'd like to give the mic to Mr. Yevhen Zakharov, who I would like to ask to cover the submissions we did, and Kharkiv Human Rights Group was leading in most of them, and you were uniting the lawyers in this area.
Добрий день всім. Я хотів би сказати, просто виправити, що...
Greetings, everyone. I'd like to correct you a bit that we have not 8 but 9 submissions. So here you have 8 of them. 7 of them were made in KHPG, 2 more, that is the work of Fidage, of our partner in France, in Paris. And that is a proof. Because Russian propagandists, the things they were doing is also the part of the genocide program, and the last 9th one is about the explosion on Kakhovska Dam. Why these submissions are important? Due to the fact that all these submissions are based on the information which was collected and structured in databases which were established back in March 2022. Moreover, I can say that this database was established back in 2015 by our organization, KHPG, and we had 18,800 victims and more than 20,000 of various objects, municipal and infrastructural objects which were destroyed. On that stage of the war, but we decided to start from scratch, and after the full-scale war, we started the new statistics. And now, as it was already mentioned in this database, we have around 85,000 crimes where we can see the features of the war crimes and genocide and crimes against humanity according to the Rome Statute. But there is another database which we have in our organization where you can find only those episodes which have now the status of investigated proceedings, which no one can see except for those who are working with these documents and also the representatives of the victims in these crimes. And we have more than 15,000 of them. So all in all, in our databases, we can say that we have more than 50,000. And in the end, the Office of the Prosecutor General has recorded around 150 crimes according to the Article 438. So in our databases, we can say that we have reflected 2/3 of these crimes. On the one hand, it's kind of a lot. On the other hand, it's unfortunately not true, because the real numbers would have been if these proceedings would have been represented in our database. But here we have some objective reasons. So let me name the main one. 85% of the episodes in our database are the episodes on the loss of property and houses. That are the attacks on the other civilian objects, infrastructure, and that are the cars, vehicles. And we have to say that the same thing happening with the general number of with the general proceedings led by the Prosecutor General's office. And unfortunately, Ukraine law enforcement doesn't have enough resources to investigate these crimes. The Office of the Prosecutor General for a long time has prioritized the topics, so the things they're working on. First of all, that are the fallen civilians, and second of all, that are wounded civilians, and third of all, that is illegal detention and illegal imprisoning. The fourth one is abduction, and the fifth one is torturing. So no matter whether the person was abducted or he or she was arrested as the witness, later these people who were arrested in different ways, they had the same destiny. They got in the local they got the tortures, or the closest one, where they were tortured very badly. And they were trying to break them physically and mentally, and in the other ways as well. Well, in fact, these 5 types of crimes are investigated the most by the State Security Service, by the National Police, and also the other law enforcement authorities, which have the investigating bodies, even NABU and the others. So all is due to the fact that we lack human resources. After the Second World War, we have never had the wars of this scale. As for our database, well, it has unfortunately some disadvantages, because not all of the crimes which were according to which we had the proceedings, not all of them are recorded. And why the criminal court we are referring to? It's due to the fact that in the beginning, the financing of this work was provided, and quite a sufficient one. Then later it was reducing, and since the 1st of June 2024, we had no financing of this project, and the documenting was made by some enthusiasts and those who were able to get some financing for this work. Because doing it without with any kind of financing is impossible for a long time. At the moment, we are looking for financing, and let's hope we will find it, because this work is really very much needed. The crimes have no expire date, and we will be able to investigate them even later. Beside that, this database is the grounds for the analysis of these crimes, and having the information in this database, we prepared these submissions we were talking about. So at least I can say that about 7 submissions which were prepared by our organization. Well, the first thing we were doing was the simultaneous work. The first thing we were doing is we were studying the shellings all around Ukraine. We've seen the same picture, and we have made the submission on the shellings in Ukraine, which and in this way identified some possible crimes. Why possible? Because only the International Criminal Court could say whether it's a crime or not. Nevertheless, this work provides us evidences, and these evidences can be later used. At the same time, we were working on Mariupol, and first of all, because the events in Mariupol started back in 2022, and they ended in May 2022. So that is an event which has ended. We have to say that genocide, and we are saying that in Mariupol we've seen the example of the genocide, that is the finalized crime which has ended and which we can study after that. That is something we were doing, and in fact we had lots of publication. That is a very complicated work, first of all because starting with the 2nd of March 2022 in Mariupol, there was no access, no internet, as well as no access to utility services, water supply, electricity supply, gas, and the other things. And people could not find out whether their relatives are alive or not. And therefore, we have invented the methodology of investigation and the way how we were finding the people, the events, and we were doing that for quite a long time, and we have prepared the huge submission which we launched in the end of August 2023. And I have to say that a famous expert in the criminal court, when he was presented this book in English, he said that if there was genocide somewhere in Ukraine, then it happened in Mariupol. But I can say right away that it's hard to prove that, because until the moment when Mariupol is still temporarily occupied territory of the Russian Federation, investigation which should have taken place by the Office of the Prosecutor of the Human Rights Office, and therefore this work is paused till the moment when Mariupol will be released until it becomes the Ukrainian territory. Only at that moment we will be able to start working there. The second work we were doing simultaneously is related to the abduction of Ukrainian children. And here we also say that it's the genocide. In fact, as most of you know, back in 2024, the Office of the prosecutor of the International Human Rights Court gave two orders regarding abducting Ukrainian children, and his ombudsman on children's rights, Lvova Belova. But let me remind you that this it was according to the 8th article of the Rome Statute. So it was said that it's a war crime. And this work, our work, is in fact justifies that that was not a war crime, but genocide. And that is what this work is dedicated to. And I think that in fact, it was highly evaluated by Ukrainian national authorities, and at the moment we have some agreements with the State Security Service of Ukraine and the National Prosecutor's Office, but now this work is paused due to different reasons. I cannot name you the reasons, and it's not my... I'm not authorized to do that, but there is some certain agreement on this, and I think that we will return to it soon. So I also reminded the philosophical principles, which is justice does not have the expiry date. Not only the crimes do not have the expiry date, but also the justice does not have the expiry date. So we are going to work with it until we will be able to prove that it was a genocide. And I think that Ukrainians' position should be only formed in this way. The rest of the submissions refer to the widely well-known crimes, but we are proving that were the crimes against humanity. We are talking about executions without courts, which happened in Bucha and in other places. They had the same scenario all the time, which we also covered in this investigation, in this research. And in Bucha, our organization works with the criminal proceedings on the deceased, and we are participating in the investigation of this. In all, we have 4,700 investigations, and we are working with those 5 types I have already mentioned. The criminal proceedings on sexual violence, sexual harassment, they are also, we're not separating them. That is a type of tortures. So therefore we have 5, not 6 of them. So the most cases we had from Bucha, of course, and we are proving that indeed that was the crime against humanity. This work, in this case, we are talking about what I mentioned, that are illegal detention, illegal imprisoning. So we say that it's also the crime against humanity, but nevertheless, at the moment when we were doing this research, these kind of cases were identified only in Kharkivska Oblast. In the rest of the oblast, we had just 1 or 2 cases, or we even had none of them, and therefore we decided to do this work only in Kharkivska Oblast, and at the moment we will do the update of this submission to cover the entire territory of Ukraine, and to make this submission once again with the cases which we received recently. On all 10 in 10 oblasts of Ukraine where the military actions took place, where the hostilities took place, and on those territories where we had the temporary occupation. And here we have the submission on the tortures. It's a new one. It's 2009. The ninth one. It was published in December 2024. It is quite voluminous. So we have 56 cases of different tortures, and the main thing is that it includes civilians, and we are talking about the temporary occupied territories, but nevertheless we have also the servicemen in captivities, and they are facing extreme tortures, and that is one of our main objectives. Tortures of those who are in captivity, both servicemen and civilians. So this work it was not presented, even though it is published, and it was reviewed on our website. All of these documents were published in Ukrainian and English language, and they are available on the website Tribunal for Putin and Kharkivska Human Rights Group. And one more submission was sent. I cannot show it right now. That is a submission on the abduction. And we have even more of them than it was mentioned in the presentation, because in each of these submissions we had a the final deadline, final date till which we collect the data. So we were collecting the cases on each topic, and then we were working with these cases, and we were providing the justification on these cases, even though it's clear that the number of these cases was increasing after the submission. Well, for example, there was the number of the civilians fallen in this document. 5,775, and we have 12,000 of them. And the real statistics can be seen on t4pua.org. That is the same website which the Kharkivska Human Rights Group has launched in the beginning of March 2022 in 7 languages. And there you can find 2 types of statistics. The first one is the statistics from the databases on the number of the crimes and the events and the objects of the attack, human losses. So the preliminary qualification of these crimes according to the Rome Statute. And it happened all around Ukraine. Each of you can use your phone and open t4pua.org and open the recent statistics. It is updated at 8 a.m. each day. Beside that, we have a very strong statistics, very important statistics on, let me rephrase it, detention centers. So there are prisons in the detention centers and the other non-standardized places of imprisonment on the temporary occupied territory. And there are 115 centers like that in the Russian Federation where Ukrainians are kept. And on the temporary occupied territories, we have around 200 places where Ukrainians are kept on the temporary occupied territories, and the total number of the people is still in captivity is still unknown for both civilians and servicemen. But we can make some certain assessment, and I can say that in the beginning of February 2025, according to the registers of the Ministry of Internal Affairs, we can see around more than 63,000 people, both servicemen and civilians, who are missing. even though more than 4,000 people were crossed out, and they were crossed out because they were found in the other countries, or civilians in Ukraine were found and they are alive, and now it is well known, or those who are fallen and there is a decision on them. So they are out of these statistics. So now this number is 10,730, and it means that we had more than 73,000 some time ago. So there are both servicemen and civilians, and the number is quite significant. 2024 and the beginning of 2025 we dedicated to identifying the location of these people. We identified more than 3,000 of these people. But nonetheless, it's a small number, in fact, because the Russian Federation is hiding these people. But that is not the topic of today's meeting, so let us continue. And we will have the questions. Okay, thank you very much. And thank you very much for a huge work done. And let me pay attention to the unique submission related to the hatred speech and the crimes against humanity. That is the submission we've made together with the International Human Rights Federation. And why it is unique? Because that is a submission concerns 6 propagandists, and that is a unique topic in the international humanitarian law. Unfortunately, we do not have that many stable definitions on how the war crimes and genocide episodes and crimes against humanity can be related to propaganda. But this submission describes, we have analyzed more than 300 of hours of this propaganda work of the Russian Federation. We strongly recommend you to read the research. We will definitely send you the post materials. We will add the final non-submission, which was already communicated with our international partners and international organizations. But this ninth submission was not presented. So today we will have this presentation. One of the most frequently asked question, which we hear as Tribunal for Putin, both in Ukraine and abroad, that is, your Tribunal for Putin, you mean court, so you are working for the court to happen. And in this case, I'd like to give you a small insight. Tribunal for Putin, that was a technical name, and we were using it till the moment we made the better name, but then we got used to that, and that is tribunal not for one person, but the tribunal for the Putin system, which led to sufferings, and that for 11 years we have the military aggression from the Russian Federation. But at the same time, the establishment of the tribunal against the aggression for our initiative is one of the key requirements and key advocacy points. So I'd like to ask Vladleva Padun, and Letitian of the Ukrainian Helsinki Group on Human Rights, one of the co-founders of the Tribunal for Putin from the very beginning. Could you please cover this point? What do we think about this tribunal against the aggression? What would we like to see? Well, greetings, everyone. I'd like to emphasize that the crime of aggression is one of the worst international crimes, and that is the crime of the crimes, which leads to the crimes of war crimes and the other types of crimes. And considering the fact that the crime against humanity is in Article 8.8, nevertheless, the international community and the practice of the implementation of the criminal court regarding this article is still on pause, because there are few reasons for that in the context of the aggression of the Russian Federation against Ukraine. And here we have the requirements regarding the fact that the Rome Statute has to be ratified by both sides to the conflict, that is, both the Russian Federation and Ukraine. The Russian Federation did not ratify it, and Ukraine, as of the 2022, did not ratify the Rome Statute. And the important aspect here is that the world community, with the political carefulness, consider this article, because there are the concern that maybe the precedent of punishing for this crime in the context of this can be applied against them, for example, for the activities like for the US in Afghanistan or the other missions. In the context of Ukraine, having the understanding that there is some certain gap in the possibility of acting according to this scenario, we have selected the model of the establishment of the special tribunal for the crimes against the aggression crime in Ukraine. We consider different options of establishing it, and one of the best one and probably the most efficient one in this situation was the model, so to say, the European Special Tribunal, based on the partial agreement of the Council of Europe, and thanks to it, we will be able to establish, so to say, the president of the Special Tribunal for Putin, a military commandment, and the Putin system. Why did we choose this model? At the moment, we have lots of work being done in this area. This special tribunal will be operating on the grounds of two documents, that is, the expanded partial agreement. This is not the new practice of the Council of Europe. The Council of Europe has around a dozen of these kind of documents. So this model of the engagement of the state, which are the part of the Council of Europe, allows to unite different countries who have the same objective to punish the Putin's regime. And the second document, that is a document of agreement between Ukraine and the Council of Europe, which will allow Ukrainian legal system to provide the evidences to the system of the investigation in the newly established, which will be a newly established tribunal, and will allow Ukraine to pass all the documents regarding the crimes of Putin and his regime on the territory of Ukraine. Beside that, the third document, which will be the most important for the tribunal itself, is the statute of now it has the name, the project of the Rome Statute, and at the moment we are working on it, and it will include the key principles which will show how the tribunal will work and how the experts will be engaged and similar things. So these three key documents will be the grounds of the work of the special tribunal of the aggression crime, and I hope, all of us hope, that in the future we will see not only the investigations but also the punishment, bringing to justice. In the context of this special tribunal, recently, a few days ago, there was a message that specialists and experts of the coalition, which was established, that is around 40 states, which supported the initiative of the establishment of the special tribunal, they have informed that they have processed these three documents, analyzed three documents, their drafts, to implement them. And Tribunal for Putin, Ukrainian Tribunal for Putin, as our initiative, we hope that, thanks to the fact that we have support of both the Council of Europe and the European Union and some other countries of Europe and the world, that in the near future, this tribunal will be established, and it will gain the objectives which not only Ukraine has, but also the other countries of the world, because that is a positive step. That Ukraine has united all the countries around it, and that this tribunal will be established as the international law enforcement mechanism of which will be able to punish. That will be the unique precedent, because the criminals will be punished, because not only Ukraine is interested in this satisfaction, but the entire world, which understand that the aggression crime cannot, we should not forget it. And each citizen of Ukraine, each citizen of the world completely understands that that's not the special military operation which has legitimate objectives, and that it's a crime which is the threat to the world order. And we can say that the activity of this special tribunal, the results of its work, they are, so to say, they show this resistance of the civilized world and the civilized systems against authoritarian and totalitarian regime of Putin, which we can see in the Russian Federation. Thank you, Vladlena. And of course, we hope that it's not going to be the single mechanism. And in fact, establishing the new mechanisms is always harder than to develop the existing one. But there is another one unique thing which already becomes more commonly used, and which Ukraine at the moment can be using in legal sector, that is universal jurisdiction. So you know that there are the cases where some decisions were already made, and recently in Finland there was a case regarding the war crime since 2015 on the territory of Donetsk and Luhansk Oblast, and that is a thing I would like to ask you about the universal jurisdictions and the possibility of using Vera Kozliev, the legal director of Truth Hounds. Vera, please, the floor is yours. Greetings, everyone. Thank you very much, Alexandra. I'd like to start with the one thing. When we're talking about the universal jurisdictions, we understand that it's one of the mechanisms which exist in all of these architecture of the authorities of organization and authorities, which have to help us to punish for the worst crimes. And Truth Hounds, as Sasha has already said, we are organizing the investigations, and we identifying some certain facts. So we identifying the possible war criminals, and at the same time we rely on different mechanisms, not only in universal jurisdiction. That is also the international criminal court, and today we are preparing the submission of the sexual abuse of men, and we were talking about a huge number of crimes, and we were talking about the big number of actors who are documenting that, and that the crimes in Ukraine, they are one of the most documented in the history of the world. And for us, it is also important to keep this principle of the comprehensiveness, and to do extra work without duplicating the work which was already done by someone. And even if we rely on the International Criminal Court, not the national courts, we still try to prepare the reports on the patterns, on the systematic crimes, so where we can see some system, or where we can see some certain type of war the Russians decided to have, and that can be also not something in the criminal. It can be not only be the criminal prosecution. For example, we had the submission to the Committee of the UN on Human Rights. We do that to understand the general framework of Truth Hounds, and also here we have the place for the international jurisdiction. The mechanism itself was very much discussed among the international organizations, whether it is efficient and whether it's useful, because it's somehow difficult, and we had to understand how we can use it and in which cases. And why do we need it and how can we use it? So just a few words on what is universal jurisdiction, or also it is called extraterritorial jurisdiction. That is a jurisdiction of the other country which has the authority to investigate and to war crimes committed on the territory of the other state. So if we are talking about universal jurisdiction, in this case, there is no requirement on any kind of relation of these crimes to the other countries. So it's not obligatory that there is a bound to the criminals or any other requirement which relates these crime to some country. If we're talking about extraterritorial jurisdiction in general, then there are the countries which can consider the crimes committed in Ukraine or the crimes against humanity if there are some certain additional reasons foreseen by the legislation of such countries. And in fact, considering these opportunities of the on the authorities, so when we have some results, when we have some information collected, we make the decision which jurisdiction shall we use to make it at most efficient. And what do we take in account when we choose a universal jurisdiction of the other country? So, of course, first of all, we do the analysis of their legislative framework. We are considering the options of the legislation of the country. And first of all, we are looking whether this legislation is oriented on the witnesses and victims, so who are in our investigations, who are providing us with the comments. And for us, it is important for these kind of things happening in the best interest of such people. And therefore, we pay attention on the opportunities in some specific country to protect the human rights of these people, to protect their safety, because in some of the countries, the safety standards are much higher than Ukrainian ones. And third of all, that can be related to the fact that the people are on the territory of such countries. For example, recently we had the questions regarding some specific crimes. We have quite sensitive information, and I'm not able, for example, provide you with all the information regarding some certain facts and cases, because this information is somehow sensitive. For example, because the people are on the territory of such countries and they need additional protection because their evidence or the crimes can be on the territory of these countries. So it's important to make these people see the justice. And considering all these factors, we decided to use this mechanism. And how are we doing that? To make it clear, how do we refer to the other country, and what is the order, or that is just the request, or how does it work? In our practice, I would like to identify three components which are in place. First of all, we are collecting the information ourselves, which can be further used as the evidence in Ukraine or on the territory of the other countries. So we are passing the information about the crimes, about the violations regarding some possible criminals or some certain case. Besides that, this information is passed, is not only passed, and so there were the cases when we were providing them with the big massive of information, and we have OSINT department which collects this information. Beside that, we have the monitoring department which work with open data and systematically collects data, and also that is documentators department, that are the people who go on the field trips and who collect the evidences, and they are collecting the evidences and the comments of the people. So that is one of the blocks on the framework of the general jurisdiction. The second block, which is a new practice, it is reflected in our submissions when we, for the relevant authorities, justify why these countries, why these authorities have to start this proceeding. This justification includes legal justification, and we refer to their legislation, which and also other factors and causes which can lead to the fact that they will get interested in this kind of proceeding. And the third block I would name is that we are trying to demonstrate in these submissions of the relation of the evidences with those elements of the crimes which we connect to some certain crime. For these relevant authorities to see some certain perspective that these conditions that these crimes can be identified and these crime can be proved in their jurisdiction. And at the moment, we have referred up to 5 submissions, so that is maybe not a significant number, but nevertheless, for us, it is quite significant because, first of all, these submissions refer to tortures, to inhuman activities against Ukrainians, and also sexual abuse in captivity. So that are the most violent crimes, one of the most violent, and for us it is a significant result. And second of all, those submissions which we've made, they were made together with some other organization, and let me name these parties. So today we talked to FIT in France. We are cooperating with them, with Colonial Foundation for Justice. So we also had the submissions which, for example, the initiative for dog is not on the general jurisdiction, but we cooperate with this organization. It was out of the criminal prosecution, but nevertheless we are joining our efforts, and I think that the cases which are prepared in this way, due to the fact that they have to meet the highest international standards regarding the information, data collection, because that are the other countries which are relying on the international standards, and that is the value of these submissions. And we appreciate the support of the partners for sharing the expertise, and together, in our opinion, we are able to have the high level of meeting the high standards of these submissions. And we also rely on the positive results, on opening the proceedings and on the further results of these proceedings. And without names, I will say that one of the submissions we've already made by Truth Hounds to the Switzerland. In 2024, we found out that the proceeding started on these facts, on these were criminals which were identified as a result of our investigations. And also we have the crimes against humanity which were committed 7, 8, 9 years ago. And for us, it is also important to demonstrate, so to say, the systematic nature of these crimes. And they were committed not only after 2022, but they were committed back in 2014. And it's what also mentioned today, lack of punishment and the possibility of impunity creates a new crimes, and therefore it is important for us to get the result, because in this way we can demonstrate that even after 10-15 years these people will be punished, and maybe it will have some preventive role to decrease the number of the crimes which are committed now. And speaking of the universal jurisdiction, the last thing I'd like to mention, how can we use it? And why, in fact, we are doing that? Because, for example, in the other countries, there might be the opportunities, and they can find this person around the world. The rest of the assets, which is quite painful for the representatives of the Russian Federation as a tool of the influence. And also, beside that, we can these kind of tools can be used. But beside that, I can say that broadening the coalition of the countries which are the part of those who are fighting for the international justice, and they start to feel this, and I think that is an added value, because for them it is also important to to get the results of these cases. And in addition to that, I think that it was not mentioned, we have information and advocacy work, and it seems quite legal, but nevertheless, I think that it has a big role because we are able to inform, and we are the voice of truth about what is happening in Ukraine. And in this way, we raise a trust to the decisions of the courts regarding these cases, because in this case, we prove that the investigations were objective. There, thank you very much. And indeed, there is one more big advantage of any kind of the decision made or even proceeding if there is no decision yet. That is a good standard and example for the national judges and how to consider these cases, how to consider the international crimes. And with this, I'd like to give the floor to Yulia Bohdan, the director of the Center. The director of the Center for Law Enforcement Research, CLEAR, in one word. And Yulia, I'd like to ask you to cover our national system. Truth Hounds has already told us how we are trying to interact with the international system, but in fact, all the members of Tribunal for Putin are cooperating with the Office of the Prosecutor General, with local prosecutors. And this interaction happens not only in the informational field, but also in, so to say, legal support. And of course, also in education. So we have to understand that investigators and those who are working on these crimes, on these cases, they have a unique challenge, that is international mathematics, which is at the same time has to be reflected on the national and international level. So Yulia, the floor is yours. Greetings, everyone. I think that we can divide it into branches. First is punishing for the crimes of, so to say, small crimes, small people. That it means that investigation has to be done according to the higher commanders, according to the orders of the higher commanders, and typically it was regarding civilians on the territory, on the temporary occupied territories. Big investigations can be conducted only when the territory is deoccupied. Me, as lawyer, was supporting Maria Krzyzewska. The girl was killed during the occupation in Izum town, and only after deliberation of these territories, we were able to conduct the sufficient pre-court proceeding, and we were able to conduct exhumation and identification of the real reasons of her death. This case proves the sufficiency and efficiency of all the work and the decision and the court decision. Speaking of the military crimes, so we can be considering it in the same group, and the important element in this case is that we have to engage the military tribunal, and they have to act in accordance to the national legal system. Speaking of the second branch, second direction in the international law, that is a punishment and decisions and also the proceedings on, so said, big fish. That are the commanders who were giving these criminal orders, who the small people were doing. I'd like to emphasize that objectivity of the necessity of engaging of all the national court authorities to these cases, and also we have to record all of these, sufficient recording of all of these stages, and this will give us the opportunity to consider the case to be considered objectively, and that investigation was sufficient. Meaning that after the identification of the fair and fair peace and justice, we will have the new opportunities on punishing, on bringing to criminal responsibility for committing the military crimes. Thank you. Thank you. And the next person, I'd like to cover one more important aspect of NT4PUA when it comes to justice. In fact, we are very glad that in Ukraine, finally, justice starts to get the new sides. Of course, we understand that justice means prosecuting and punishing aggressors, those who commit the crime. But the second part, which is also mandatory for the justice, that is recovery of the rights of the victims. And unfortunately, Soviet practice for a long time didn't care about this part. And in 30 years in Ukraine, we finally came up to this understanding that support and interaction with the survivors and also with witnesses of the war crimes, of the crimes against humanity, genocide crimes, and illegal imprisoning, that is also the big part of justice. And it starts with recognizing the fact that the crimes happened to these people, and for this you do not need to capture Putin, to engage Interpol, or to find literally everyone who committed these crimes with their own hands on the territory of Ukraine. Because people who were affected, victims, survivors, families of the survivors, we have in Ukraine, and that is our home task. So Mr. Igor, the head of the Association of Relatives of Kremlin Political Prisoners, one of the oldest organizations which was established to the initiative of highly motivated people whose relatives were the first, so to say, wave of illegal imprisonment as a result of the military aggression of the Russian Federation. Thank you very much. We are talking for quite a long time, so I'm not going to cover it in all the details, but let me focus on some small peculiarities. So first of all, we think that recovery and rehabilitation and returning civilians to normal life, civilians who went through illegal captivities, all these processes, all these programs have to be the part of the strategy of the release, the part of the strategy of punishing, condemning the actions of the aggressor. So we cannot just punish the people and release the people and leave them alone. So with the experience they got, they are going to need huge support from us as society, and we have to be ready to provide them this support. At the moment, Ukraine, on the 11th year of the war, is not ready, unfortunately, to provide this support. And luckily that in 2022, we had the law on the social and legal support of the people who were in detention, and we had some kind of legal regulation of these issues. But in fact, the law is quite sufficient, but unfortunately it does not work in Ukraine. And for it to work a bit better in Ukraine, in March 2024, we have adopted the decree 256, which identifies the post-isolational activities, and that is the only thing we have so far, at least some decree which regulates something. Unfortunately, at the moment, this decree is quite general, and it's not clear, and it discriminates civilians who were in detention or in captivity, and they do not have the right for the support. And in fact, we are advocating for the amendments to this legislation, because we have to understand that it's not due to the fact that the law is bad or the bad people wrote it. But the thing is that the law was adopted 1 month before the full-scale war, and objectively, it could not take into account the reality which we are facing now. That was back in January 2022. Before 2022, we had lots of people in detention. We knew where they are, we knew who were they, and we could identify where they are kept. And typically, these people faced illegal prosecution. And now most of the civilians which are in illegal detention, they are incommunicated. My colleagues were already speaking of that. We do not know where these people are. We do not know what are the conditions. The Russian Federation skips this question. The Russian Federation ignores the request. It does not provide the information. And we know that most likely that it's dozens of thousands of people. And according to some assessment, that is around 20,000 civilians, but we do not have enough information about these people. So what do our legislation say now? Why we are criticizing it, and what do we suggest? Our legislation says that these people, after their release, have to give the full rehabilitation, full medical assistance, psychological assistance, and the state has to pay for that. And that's logical because people were affected due to the illegal detention, illegal actions, and the state as the leader of the as a guarantee of the protection has to help them because it was not able to protect them at some certain point. And the decree number 296 identifies that all the servicemen after their release, so they can get this assistance, all the civilians can have it. But we have to understand that, like, look at the statistics of the coordinating headquarters. If I'm not wrong, around 300 civilians were released in 3 years. So out of the general number, according in the framework of the exchange, civilians are around 5%. So that is a very small number. And civilians who are released from the illegal detention on the temporary occupied territories, where they are kept incommunicado and they are released themselves, we have more of them. We do not know even how many of them. So that means that these people were kept there, they were interrogated, they were tortured. Some of them were used to as there was a labor exploitation, and there was the other reasons why these people kept. And then they have so many of them that these people are released. Or maybe these people who have no more, they did not bring any benefits, and the people were dying and they were thrown away. Or, for example, the armed forces of Ukraine were releasing the towns and cities, and they were releasing these people because the enemies had to protect themselves, and they could not take this number of the illegally detained people, lots of different reasons. And now the people are released. And the recent event I've heard of, the person released him or herself just 1 week ago on the territory of the Zaporizhzhia Oblast. And now this person is on his or her way to Ukraine through the third countries. And these people who are released, not themselves, not through exchange programs officially. So the country says, okay, prove that you were in detention. Prove that you were not just busy, or that you were in Crimea. When there is exchange, it's quite clear. Ukraine comes to the demarcation zone, and that is a proof that these people were kept by the Russians. And those who the Russian Federation releases, or they are able to escape themselves, what should we do with these people? So this group of people, that is the biggest, the majority, and the commission in the Ministry of the Region has a huge problem with proving these facts. And we were writing the expert research, which was issued in December 2024 on our website, and you can find it. I'd like to thank all media which covered it. Yesterday, Ukrainska Pravda has published my article, around 60,000 reviews, and that gives a hope that this topic will be the top topic and people will pay attention to it. And these people do not know how to prove that they were illegally detained. Nobody explained them. And the legislation does not give you the answer. The thing is that even the members of the commission do not know what to do. And for them, it is easier to refuse than to vote for. And what if this person is lying? What if something is wrong? So members of the commission, they even do not know what kind of requests they can make to get these proofs. So that is a very big problem. So why did I mention that? These people, we have thousands of them, and at the moment they are arriving to Ukraine, they return to Ukraine on the territory which is controlled by Ukraine, and they do not get any rehabilitation or psychological assistance because the fact of their detention was not proven. And that's it. And that is the reason why lots of people were interviewing the survivors, the witnesses, when they are escaping from the temporary occupied territories, they are deciding to stay on the territory of the third countries because they are provided with more assistance there than in Ukraine. Considering their status, considering their experience, they do not get more assistance here than in the other countries. So there are different approaches. So we are kind of ready to provide the assistance to some people, but until the moment when the fact is not proven, we are not able to provide any assistance. How to identify whether it's true or not, we do not know. So we write it in expert review, and we make the suggestions. We make the suggestions for the amendments to the legislation and recommendations for the survivors. But one of the key advocacy things, one of the key cause is that we have to harmonize our law on the social support, harmonize with the Geneva Convention to say that any civilian who is kept in detention illegally is considered to be a facted survivor. And now, according to the law on the social legal assistance, it's not enough to be just civilian who was affected, but you have to prove that you were activist or something else, a volunteer, or you have to prove that the enemy had the hidden motive to keep you in detention. And when people are reading that, they are just reading, they cannot even... They have no hope that they can get something. Yes, you can get something. You can contact us and we will help you, and we will help you to do that. That's really hard, but nevertheless, that is important. The law has to be changed, and the framework of the support which the state has can be providing should be broadened, and we have to engage everyone there, both farmers and entrepreneurs and all types of civilians who did non-activism, but they were affected because the enemy took everything, they were tortured, and they have the right for these kinds of support. I was mentioning the Decree 296, which formally declares that social, medical, and psychological assistance will be provided. But even that, those category of people who were exchanged, so it's hard to understand what kind of assistance is that. What kind of assistance they have the right for? A medical, rehabilitation, or social. So what is the volume? What is going to be free of charge? And what will you have to spend money on? Nothing is clear there. The Minister of Healthcare says that the released after detention, and after detention they are the same civilians as we are with you, and we go to the family doctor and they have to contact the family doctor and they have to follow the general system, that is the official system position of MOH. And we think that there should be the separate programs of rehabilitation, different programs considering different experiences people got, different health issues, and the crimes which were committed against them. So I have taken down some notes. So what was interesting there, the official statistics, that is statistics of the coordination headquarters, around 30% of the people they are releasing that are the people who were missed in Ukraine. So you understand that it concerns both civilians, because a big number of people are returning, and the fact is not identified. Another reason, when the relatives know that their relative is in detention, but they are not contacting the ministry, and they therefore I'd like to ask all the relatives, when you are afraid of something, when you don't know something, you can ask for a consultation. It's free of charge, and that is something we have to do, because when your relative will be released, if until moment you will go through all this way of the identification of the fact, this person will be able to get some financial support from the government, or will be able to get rehabilitational support. So speaking of the rehabilitation, at the moment, so far everything is quite sad, because nobody is studying this issue. There is no tradition in the state authorities of studying the needs of the survivors of the affected population. So there are some kind of standards probably back from the Soviet times, and it's easier to sign some order according to those standards, and that's it. And therefore the Minister of Social Policy, in my opinion, we're very proactive considering the situation they are in. But nevertheless, a program which they have established now on rehabilitation, sanitary treatment of civilians after illegal detention can be held after during next 12 months with a budget of 16,000 hryvnias. All of us understand that around 350 euros. We understand that after the tortures one is facing, 1,000 hryvnias is not enough. You know, for example, that in Truskavets, the room is even more expanding, and considering the fact that some certain procedures have to be provided, services have to be provided, it costs even more. So we have to make these numbers more realistic and make them closer to the needs of the affected population. The last thing I'd like to mention, and we are now talking not only... We just do not want to increase the budget. We have to increase the budget, additional costs, because all of these are money. We don't have this money. We depend on donors. Well, that's not only about the state budget. It's proactivity about the readiness of the state to act, because in October 2024, the Parliamentary Assembly of the Council of Europe has adopted the resolution on the missed Ukrainians, and in the provisions you can find the recommendation. The state of the member of the Council of Europe has to conduct the actions directed on the launch and the support of the rehabilitation programs for the affected Ukrainians. And there are lots of countries who are ready to share their money, their expertise, and to provide their own infrastructure. Some said that this program, nobody said that it has to be held only on the territory of Ukraine. This program can be held on the territory of the European countries, and we would like the state to initiate this kind of program. Thank you very much for your attention. Thank you, Igor. I'd like to remind you that we have International Register of Losses, which is opening the new categories, and therefore, dear colleagues, suggest your beneficiaries to contact the register. It also shows the scale of the destruction caused by the Russian Federation. And I know that it was quite lots of questions, lots of topics which we highlighted in the present. But nevertheless, in 3 years, our initiative had the opportunity to contribute in all of these topics, and we will continue doing that. And at the moment, we have the time for a Q&A session and the comments from your side. So please, if you have the question, please raise your hand. Please. We have the mic. Please introduce yourself. Greetings, I'm Natalia Staroprava, Espresso TV channel. A bit more about the Tribunal. Do you have any solid achievements? What are they? And as far as I understand, the Tribunal is something not of the next 3 years, but probably of the dozen of years. Or maybe you have some framework or timeline. When will we see the first steps, and what are the first what are the first steps, and what are the challenges in punishing and what should we do? With this, I'm passing the floor to Vladlen, who covered our vision of Tribunal against the aggression crime. At the moment, all the international community, around 40 states which joined the initiative which supported the establishment of this tribunal, they are creating the tribunal because at the moment the Article 8 cannot be applied, and therefore this, so to say, unique mechanism which is going to be established on the level of these states, world states, which will later join this broad and partial agreement of the Council of Europe, well, that and the statute of the special tribunal, that will be the start of the work of this tribunal to bring to justice the Russian Federation as aggressor state, and Putin and the management of the Russian Federation to justice. And therefore, speaking of the timeline, is quite hard. Of course, we would like it to happen as soon as possible, and for it not to take too much time, because we are now in the 4th year of studies, and therefore it's hard to be saying that one year, in 2 years, we'll have the tribunal and that everyone will be punished immediately. All of us are quite conscious, and Ukrainians have to be conscious of that it's not as simple and it's not a fast process. At the moment, comparing to everything we had before regarding the models, regarding how this tribunal should look like, and whether it should be the tribunal on the grounds of the national system, where international partners will be joining in the context of the expert support, some diplomatic or political support, or maybe it is going to be one of the model we had is on the basis of the Security Council of the UN. But one of the, in my opinion, the most efficient is a third model, that is a European, so to say, European model, where the basis is all the states, not only Ukraine, but all the states. Not only Ukraine is going to lead this process. This is going to be led by the Council of Europe, but Ukraine was thanks to the agreement which must be established between Ukraine and the Council of Europe, will be able to pass a materials we have got through the law enforcement, through the prosecutor general, and we will direct them to the prosecutor of the newly established authority, and the investigations will start. And we cannot say what will be the stages because we don't have the statute so far, but as of the 20th of March 2025, according to the statements of the Ministry of Foreign Affairs, the 3 drafts of the 3 models, the broad and partial agreement, the agreement of the Council of Europe with Ukraine, and the statute, we have developed them. They are not published to well-known reasons, but the progress is in place, and I hope that we will manage in the future to observe not only the process, but also the result. Thank you, Vladlena. Another thing I would like to add is that Ukrainian society should not narrow down the expectations regarding justice to one mechanism, which is still hard to launch a tribunal for Putin, and that is the reason why we have this kind of coalition of the Union of, and that is the reason why I have the name. There are a few aspects of which we were discussing today, that is justice on the national level and using the international mechanism we have. And therefore, we have so many submissions to the International Criminal Court. And, of course, using the universal jurisdictions and, of course, the support of our survivors here. So, Tribunal for Putin. We are not focused only on one document, and therefore it's not a problem that it's not established yet, and that it's going to be established during the next 10 years. So there are the other ways to get justice, and it's in the best interest of Ukraine to make justice diversified. Another additional question on the EU summit, which was held last week. It was said that EU countries want to establish a special tribunal. As far as I understand, we are speaking about the same special tribunal, but there is only one country against, Hungary. Is it going to be an obstacle for the further criminal proceedings or activities? Is it going to be an obstacle that the Russian Federation is a part of the UN? Brief answer, no. You named 3 different organizations. The agreement is signed on the ground, so by the Council of Europe. European Union is the economical union, and UN is the union of more than 190 countries. No, it's not going to be. It's not simplifying the process, but nevertheless, it's not the obstacle. Maybe the questions or the comments. The head of the cooperation on universal jurisdiction. Thank you.
My Ukrainian is still quite basic for speaking. Very short question. Are you and how are you adjusting your strategies in light of ongoing peace negotiations, which we all believe could affect accountability processes on all levels?
Для нас,
Do you want to translate the question for people?
я думаю,
No, but
ні, у нас всі присутні тут.
No, I think that everyone understands, and the rest is interpreted not automatically, manually. So how do we see the strategy of the justice in the framework of the, so to say, peace negotiations? I don't know whether it's negotiations about peace, but the negotiations are really in place. The Tribunal for Putin as coalition, we are not bonding our work to any kind of results. We understand that the task we have, anyways, we will have to achieve them, no matter what happens around. I think we started documenting. We will continue it, and of course, ideally, to have more access to more resources. But even if the political surrounding will not be interested in continuing this work on the national or international level, nevertheless, we're going to continue that, because that's a part of the constant, stable, sustainable peace. So without justice, when we recover the rights of the survivors and recognizing the crimes, so we do not consider that any kind of stable peace is possible without implementation. And we should not recognize what was the Russian Federation doing during the last 11 years to be normal. And of course, that means that releasing the people is our priority, and therefore Tribunal for Putin and most of the organizations which joined the campaign, we have the principle people first, and the objective is to prioritize the question of releasing and preserving the lives of those who are now in illegal detention or in captivity on the temporary occupied territories or territories controlled by the Russian Federation. And therefore, that is not the initiative which can have an end when the ceasefire will take place. For us, this work will be over when each survivor will get some certain level of justice. Maybe you'd like to comment on that as well? Okay, so I can assume that everyone agrees. Democracy and work. Maybe some other questions? We have a few more minutes. Okay, so thank you very much for your attention. Let me remind you that the materials you have, you can use proactively. You can use all the QR codes you can find there. All these materials are there to use them. We deeply appreciate your attention. Thank you very much for the opportunity to cooperate. As you've heard in our work, as well as in the work of our colleagues, we are constantly working for the resources, and also we We will be glad for your great ideas on